Well, we're gonna start talking about bail. And if I was clever enough and it wasn't Monday morning, I would have taken that story and turned it into an arrest. And what would happen if your neighbor got arrested? We'd turn it into a bail story. But I'm waking up just like y'all, so we're just gonna jump right in. Bail. Bail is, I kind of like the way the textbook worded it. Bail is a verb and a noun. Bail is what you put up, the actual thing you put up, and it's also to bail out. I like that, the way they worded that. But what is your concept of bail? When you hear the term bail, what do you guys think of? Money? Yeah, absolutely. That's a big part of it.
Could be property as well.
Could be, yeah, collateral.
Mandatory court dates.
Mandatory court dates. Tell me more about the property though. I think most people think about bail, but you're right.
The first thing to put there, I think it's, I'm assuming it's a short-term mortgage, as it were, against the property. But I mean, we're talking about a huge bail. That's not, that's not DUI. This is like capital murder or something. You got the penalty, you could have a DUI, or you could be stand before a judge for a lien, and so.
Well, it's like a lien, like a short-term mortgage. Yeah.
It's just a promise, and then make sure that, I mean,
Is that the first
so you go to court.
Right.
So there's repercussions if you don't show up. Your mom puts her house up, and you show up to jail, and down, your mom's home.
Exactly. It kind of strengthens that promise. We all want to believe everybody if they promise that they're going to do something, but if you promise and put your mama's house up, like Martin said, then hopefully you're actually going to show up to court. So it is a way that society has come to ensure, at least as much as possible, ensure, because people do skip bail, that offenders show up for court. It can be, like Melina said, it could be money. And I think most times people think about bail as money. And even as Mr. Wall said, even though it's a house, it's money, it's wealth, it's value. Money is value, property is value. In theory, I imagine anything can be taken as collateral. Now, if you're running I've never run a bail business, so I don't know if there are gaps at where they're going to stop. I'm sure there are. Maybe you can put a business up, something of value as collateral. But in general, it is something of value that is going to be held to make sure that you show up for court, or the offender shows up for court, and then give it back. We're going to talk about kind of the ins and outs of it, but before that, let's talk about why we do it. If somebody, now that I'm a little more awake, we'll talk about Brandon's neighbor. Brandon's neighbor, in theory, trespassed onto his property. That's a crime? In general, felony and misdemeanor? Yeah, in general, misdemeanor. I mean, you can probably aggravate that somehow and make it a felony with some vandalism or some intent, but in general, we're talking about a misdemeanor. Misdemeanor, what is the exposure for a misdemeanor in general?
Less than 365.
Less than a year. Or a fine, yes. So, if you could be incarcerated for less than a year, then we can assume that one could be put in pretrial confinement, right? There are two kinds of folks that we have in jails, not prisons, in jails. There's two kinds of folks we have. We have folks who've been arrested and haven't been convicted of a crime yet, and folks who have been convicted of a crime, which is what we just said. The exposure for trespass is less than 365 days, less than a year. So once convicted, you can spend up to a year in jail. That is the post-conviction incarceration. And then we have pre-trial incarceration. Pre-trial incarceration is what we're talking about when it comes to bail. Bail has nothing to do with post-conviction incarceration. Mr. Thornton's neighbor trespasses on his property and gets arrested for it. Can we imagine if he has an exposure, if convicted of up to a year, we can imagine he's going to go to jail. They're probably not going to just write him a ticket, depending on the jurisdiction. Now, it takes a while to go to court. Our Bill of Rights says that we have a right to a speedy trial. However, there are some exceptions to that. One of those exceptions could be a waiver. Maybe his neighbor decides, I want to get the best attorney possible. I'm going to beat this case. I don't care how long it takes. I don't care how much money it takes. And he tells his attorney, you prepare as long as you want to prepare because I'm beating this case. So he can waive his right to a speedy trial. If he waives it, it could go a year, 2 years. We'll say a year. He can have his attorney prepare and go to Mr. Thornton's property and put drones over his property, and we can photograph his property. He can hire Elon Musk and put a satellite in the air and take satellite photographs of his property just to prepare for his case. It's gonna take a long, long time to do all that. If he's arrested and he's waiting for trial, he waived his right to a speedy trial, he's sitting in jail the entire time. Waiting and waiting and waiting. Some of those cases, like the one I just described, obviously absurd, is the choice of the offender. The offender says, I want to beat this case, do what it takes. However, there are other offenders who are told those same circumstances. There are offenders who are told, the attorney will tell them, I want to take your case. I can prove, I believe I can help you beat this case, but I can't do it in 30 days. I can't do it in 60 days. It's your choice. You can get a lesser attorney. You can go get a public defender who's going to roll over this case and we'll see what happens. You roll the dice. Or you can hire an attorney, but if you hire me, you're going to have to waive time. Your choice. Nobody's forcing you to do it. If you want to have the best shot, if you want to hire me, we're not doing it in 60 days. So now the offender has to make a decision. What are the pros and cons there? This is a realistic situation that happens. So in essence, what does that decision kind of boil down to in your thoughts? So you got told that you have to waive time if you want a decent representative, or if you want to hire this representative, this attorney, or you can have your public defender assigned to you and roll the dice. What are your costs and your benefits?
Especially when they're waiving up, you're waiving your right for a due trial. You don't know how long you have to wait. And
That's a big one.
Kind of encourage you to actually go for a bail.
Yeah. So if you waive time, you're in jail. Although, was it the offender's choice to do that? I mean, in theory, yeah, they are waiving, but did they want to? It's their choice, but did they want to? Right? Now we talk about bail. Nobody wants to stay in jail for a year while their attorney prepares. They want to have the best representation as possible. It's a cost, it's a trade-off. So in this case, the bail would be fairly reasonable. I don't have the bail schedule. In fact, I think we tried to look at the Johnston County bail schedule recently, and it's not necessarily as published as other jurisdictions because of some of the applications of how offenders are issued bail. In North Carolina, and especially in smaller jurisdictions, not just North Carolina, but in smaller jurisdictions compared to, and I'll tell you how we do it in Los Angeles, the two different ways. Everybody has the right to go before a magistrate and have their case quickly heard to determine whether or not there's enough probable cause to determine whether or not they should be incarcerated or not. That is the rule. In smaller jurisdictions like Johnston County, if somebody's arrested, they're literally taken before a magistrate and told the story. This is what happened, and the magistrate says, yes, put them in jail. No, don't. Here's the bail. However, in larger jurisdictions, I never worked in a small jurisdiction. I worked exclusively in Los Angeles. Unlike some, like North Carolina, you'll see people who work in Knightdale, and then they'll transfer to Clayton, and then transfer to Smithfield, and then maybe Johnston County Sheriffs. They work in several different organizations in their lifetime. In Los Angeles, in general, folks don't bounce around. I was hired by the LAPD, and 22 years later, I was promoted, or I'm still with the LAPD. So I don't have a lot of small town experience. But I will tell you, it is not, they don't have, there's no magistrate that has enough time for a population of 4.5 million people, city of Los Angeles, the county of Los Angeles, close to 10 million people. So a county judge, 10 million people, all the offenders that can come out of that population, don't have the time or the capability to have every single offender come before a judge. So what happens is somebody's arrested, there's a document that's filled out called probable cause disclosure or declaration, I'm sorry, probable cause declaration. That declaration is then within 48 hours sent to a magistrate, and they flip through them and they read them. They do the same thing as bringing it before a magistrate, except it's on paper. That's how it works. So because we don't have the magistrate there that's going to say, yes, this person has enough probable cause to incarcerate this person, and the bail is whatever they say, it's published. And it's called a bail schedule. The bail schedule is published. And let's see. There we go. Burglary, we've talked about burglary before. Burglary, residential burglary, the price is $50,000. $50,000 is the bail for residential burglary. Commercial burglary is $20,000. Possession of narcotics is $10,000. Battery is $20,000. And these are your bails. Plain as day, unless they're enhanced, unless you're on probation or some other mitigate or aggravating circumstances. 288 can be all sex crimes. Loot Act, $100,000, and it has, if the victim's under 14, $100,000. If it's by a caretaker, $100,000. Otherwise, you got contact with a minor to commit sexual offense, $5,000. Very, very documented. So these are all felonies. So trespass isn't going to be on there. But in general, my guess is about $1,000. Is what trespass would be. But we'll talk about felonies because in this case, you're probably not going to have this lengthy exposure to a trial. But if you are arrested for burglary, residential burglary, say $50,000. You're arrested for Mr. Thornton's neighbor, instead of going on his property, he goes into his house. And there's a little bit of evidence, there's enough probable cause to determine that, yeah, it appears that this neighbor committed that offense. So they're put in jail and the bail is $50,000. But they claim innocence. This is not, I know it looks like I went into his house. I didn't burglarize Mr. Thornton's house. I swear. But they're sitting in jail. They don't want to have a public defender. They want to hire an attorney, which is already a cost. And the attorney tells them, I can do your case, but I got a ton of cases. You're not my only client. I've got 20 other clients outside of you. I'm working all their cases. I'm great at what I do, and I believe that we can win this case. However, you've got to waive time. Or you don't have to hire me. Nobody's forcing you to hire me. You're a choice offender. So they're going to sit in jail for how long? Up to a year. The exposure to in a burglary is probably 3, 5, and 7. 3 years, 5 years, and 7 years. Nobody wants to go to prison for that long. So what are our choices? Sit in jail for a year while the attorney works on other cases and your cases while they can, or post bail. That's why bail becomes so important. But is it fair? Is bail fair? Without raising hands, but think about your bank account. You're arrested for burglary. If you're arrested because not everybody who's arrested is guilty. Definitely nobody who's arrested is found guilty already. We're presumed innocent, but factually innocent. Not everybody who is arrested of a crime has done that crime. People are found not guilty, and not out of technicalities. People are found not guilty because they didn't do it. There can be probable cause, which makes it appear to believe. And I'm not talking about misconduct or lies on the part of the government, but that can be part of it. But just in general, there can be innocent investigative leads that appear to make somebody guilty, and in the end they weren't. And if that's true, and somebody spends all that time in jail, They've lost that time. Think about your bank account. If you were arrested for this burglary that you didn't do, outside of malfeasance, outside of somebody lying about you, it just appeared, something happened, it appeared. Do you have $50,000 in your bank account that you just get yourself out? If you talk to that attorney and said, hey, I want your case. I think we have a great case. I just don't have the time. I can't just dedicate all my time to you. I work for 20 other people. I'm not your attorney, I'm an attorney. And they told you, I think we can win this case. But it's gonna be a year. What do you do? If you don't have $50,000 in the bank to let yourself out of jail, do you just sit in jail? How fair is that? Do you sit in jail while somebody else who does have $50,000 in the bank is in the exact same situation, and they just say, yeah, that's great. I'll waive time. I'll wait a year. In fact, here's my $50,000. I'll write a check right now, get myself out of jail, and I'll see you in a year when it's time for a court date. Problem solved. That's no problem, right? If you have $50,000 in the bank, that is no problem. I mean, it's a little stressful, don't get me wrong. You're still facing a burglary case, but you're not sitting in jail. What are the consequences of sitting in jail? Let me hear from you guys.
Lost wages.
Lost wages. Tell me about that. What does that mean?
You can't go to work, you ain't getting paid.
And if you don't make money, what happens to your family? Literally, what happens? Is your family going to suffer?
Yeah.
If you're supporting your family will suffer. Even if you're a two-income household, your family's going to suffer because you've just cut your income in half. Who's going to pay for your house? Who's going to feed your kids if you're sitting in jail? Whereas you've got this other situation where somebody just wrote a check for $50,000 and they're back to work the next day. Is that fair? What do you guys think? Because fair is a very loose word. I'm choosing that word purposely.
Yeah, that's what I was pausing for, because using the facial comparison of the word fair, it definitely isn't right. I mean, asking for bail system is discriminatory and it's poor people. It's like asking for water is discriminatory and someone can't swim. Yes.
I like that example. Thank you. Is it because like I said, I use that word on purpose because a lot of folks throw that word around. The word fair is thrown around a lot in much the same way that I hear the word harassment thrown around. Oftentimes, I find that when somebody claims they're being harassed, they have a very difficult time defining the word harassment.
Continuous unwanted advances.
Right.
Look, legally.
Right.
Continuous, it can't just be once.
Right.
Bothering, I would say, is probably the more common word that they meant to use. Pestering. I like pestering because I've done a lot of pestering in my day. But I've been pestering too.
But
Yeah, harassment is not necessarily a crime in general. Just the same way as fair. Fair is it's difficult to find a legal term for fair. We have due process.
I mean, I want to say they mean fair as far as depending on where you fall in that gap, because there's so many things that add to situations to try to make them fair, you know, or lenient or whatever the word is for that situation. Because there's, I want to say too broad for that.
I mean, I'll agree with you. It's
Because
broad.
you understand, because this person made this on paper before taxes is taken, doesn't mean that's what they have to live off of.
Mhm.
And so regardless of whatever you're going off of, it doesn't really seem to be fair regardless.
Yeah, like I said, I use that term on purpose. I think right is another throw grammar out. Mo better term. Is it right? Well, let's talk about that. Is it right? Is it right that one person can cut a check and one person can't? And they both, all situations are the same, both are accused of the same crime.
So that person that can cut that check, yeah, that's absolutely right.
It's just a matter of perception.
But those pledge, it's not gonna be.
And I'm gonna back up a little bit because I used the $50,000. We haven't talked about the logistics of bail. We haven't talked about the logistics of bail. So In general, with exceptions, we're talking about 10%. So
And everything.
it may get a little easier if one is arrested for this crime we're talking about specifically, the
Right.
$50,000 we talked about, for residential burglary, $50,000. So in general, if you go to a bail bondsman, a bail bonds person, company, they're gonna want 10% of that bail to post the other 90%. So in this case, math being what it is, $50,000, they would say, give me $5,000. I will post your $50,000 and you can wait a year, just like the guy who cut the check. Here's the difference. The guy who cuts that check, cuts the check to the court, says, here's my bail. I promise I'll show up in a year or whatever the court date. There might be continuing court dates. I keep saying a year, but there's some other court dates. If you show up to the court date at the adjudication of your hearing, the adjudication of your case, you're gonna get that $50,000 back. That's what the agreement was. I'll give it to you. If I keep showing up, you'll give it back to me when we're done.
That's how it's supposed to.
Supposed to, in theory. However, if you don't have $50,000 in your account, that's where bail bondsmen come in. They will, like I said, in exchange for, in general, 10%, you give me $5,000. A private company, not the court, a private company says, if you give me $5,000, I will put up the $50,000 for you, and then you're free and clear. You go up to court, as long as you keep showing up for court. If you don't show up for court, there'll be a warrant issued for your arrest and you go back to jail. However, at the end of that case, do you get that $5,000 back?
No.
No, that's the cost. That's how the bail bondsman makes their money. That's the profit. You can either put up the entire $50,000 and get the entire $50,000 back, or you can put up 10%. That's a loss, but you didn't just spend $50,000. Now, I think it was Mr. Martin that talked about, or Mr. Walls that talked about the use of collateral instead of cash. So in general, we talk about $10,000. Sometimes that you talk about 10%. In general, that 10% may be able to be reduced to 3%, 2%, 1% if you put up collateral instead. That's a nuance. We get a little bit of the weeds about how bail bonds work. And to be honest, having never worked for a bail bondsman, I don't know every nuance of it, but that's the generality of it. So in this case, it's a little easier to put up 5,000, right? You can write out now. One person's able to cut the check for 50,000, they get out. The other person cuts a check for 5,000 because they don't have 50,000 in their bank account, and they never get that $5,000 back. One person loses $5,000 altogether, but in exchange, you're paying $5,000 for your freedom. That's where we come to another question of, is it right? Should you have to pay? One person's paying $50,000, but are they really paying $50,000, or are they just putting it into a different pot? They're gonna get that money back, right? One person is literally losing $5,000.
And the bad part about it is the ones that lose that 5 grand, that sometimes can't afford to lose that way. You got the ones that have got stacks in a bank account because it's 50 grand, all right, cool, here. And then it comes back to it.
You don't know, if you've ever heard the term 187,
Mm-hmm.
you'll hear it in lyrics occasionally. That is the penal code in California for murder. Let's look at the cost.
What are these special circumstances?
Special circumstances are defined in the penal code as usually being affiliated with capital punishment. So if you have special circumstances, it can be filed as a capital case. Special circumstances in California being lying in wait or an ambush, killing with the motivation, financial motivation. So I'm killing you because either you're a business partner or I'm robbing you something. Killing of a law enforcement officer, and multiple murders, multiple associated murders. Those are the 4 general circumstances, special circumstances. Any one of those or multiple iterations of those committed in association with a homicide makes it a capital case or potential capital case, which means if you do any of those while committing a murder, then you can be put to death. Mere murder is not a capital offense. It has to be murder with a special circumstance, one of those 4 that I just said. And special circumstances change per jurisdiction, I'm telling you, California. Look at murder, $2 million for all other murder, not special circumstances. $2 million, what's 10% of 2 million? $200,000. That is your 10%. That is your cheap way of getting out. If you are accused of murder, if you are O.J. Simpson, who was found not guilty, was O.J. Simpson found innocent or not guilty? Found not guilty. Can you guys think of anybody who's found innocent? You're probably not going to find one because our court system usually doesn't find people innocent. It finds them guilty or not guilty. Either you prove the case or you didn't prove the case. In general, our court systems do not find that you didn't do it. They find the case proven or not proven. However, there are some exceptions there too, just like I'm always going to couch it because there are times when people are found, the legal term is factually innocent. And a lot of times that happens on appeal. They will retry the case or review the evidence and say, yes, this person is factually innocent and needs to be released, things like that. But in general, when you go to the criminal phase, before the penalty phase, either you're going to be guilty or not guilty. Very, very rarely you're going to hear somebody who was found innocent. You might hear it on the news, but is that the right term? The news doesn't always use the right terminology. You may hear somebody say, oh, they were found innocent. Look into it. There's your little trivia. You can tell they probably weren't found innocent. They were probably found not guilty, which is a lot different than innocent.
When they usually say they would brief on and say they were found innocent, you charge them later on and say the jury gave a verdict not guilty, just to cover
Here again, good example. And as I use that, I point that out for that reason, because there are some on either side of criminal cases who think they were either they didn't do it or the case wasn't proven. All the court system is going to say is the case wasn't proven. So, in this case, if this happened today, although it happened many years ago and the bail wasn't $2 million back then, $2 million. If you were accused of murder without special circumstances, and the bail is $2 million, that's, I don't know, again, without raising your hands, I mean, think about yourself. Do you have $2 million in the bank that you can pony up? Because I guarantee that you're going to want to waive time on a murder trial. You have the right to a speedy trial. If you're accused of murder, you have a right to have that, whatever speedy is in that jurisdiction. Whatever reasonable is in that jurisdiction. You have a right, a lot of times you have a right to have a jury trial within 60 days. I don't know about you, but myself, if I were accused of murder, I would not want to have my trial in 60 days. Why do you think that is? Why wouldn't I want to have my trial within 60 days?
I mean, outside of the rush, things get missed outside of that.
That's the primary part of it. There is a lot of evidence and a lot of investigation that needs to be conducted on the defense side in order for me to have a thorough and effective representation. I want my representation to be as effective as possible. And it's going to take more than 2 months, 2 quick months to get all that evidence, all those experts together. So I'm going to have to wait time. I don't have $2 million in the bank, personally. I can't just cut a check for $2 million. So they're saying, but I can cut a check for $200,000 right quick. That's the cheap way. If I had $200,000 in the bank, they're saying I could just cut a check for $200,000, I'll be good. But I'm out $200,000 forever.
They're all just sitting waiting.
Forever, ever?
Forever.
On almost $250,000 just so I don't sit in jail. And you said, what was the option?
That's just sitting waiting.
Yeah.
Learn to play dominoes.
Who has almost $250,000? They can just let it fly. It's gone forever. You might have $250,000 in the bank. But I think you'd be hard pressed to be okay with letting that go. On top of that, You've also got attorney's fees. This isn't a civil case, so you're not getting your attorney's fees reimbursed. Do you want to have, now we have the right to an attorney and to have one appointed to us before any questions. That attorney is going to be free if you cannot afford one. Do we want, I mean, if you were up on murder, do you want a free attorney?
No, you get what you pay for.
You get what you pay for. How many clients is a free attorney, a public defender? And I don't mean free as a pejorative, like literally it's not going to cost you if you're indigent. It's not going to cost you anything. But the client base for a public defender versus the client base for a paid attorney, a private attorney, it'll be a lot different. It'll be a lot more of a caseload. Now, there may be some specializations to mitigate that. You may have some public defenders who specialize only in murder cases, who specialize only in capital murder cases. And there's not going to be that many capital murder cases. So your public, I'm not going to say that every, they're not going to just randomly grab a public defender and assign the case. They're going to give you the most effective defense possible. So, and I don't, by no means do I want to say, again, I'm not saying that public defenders as a pejorative, because there's a function that is necessary in our society for public defenders. They are attorneys that are skilled at their jobs. However, the caseload in general for that is going to be a lot higher than if you went to a private attorney. You're paying for the time. And like Mr. Wall said, you get what you pay for. In this case, you may not be paying for skill, but you might be paying for time. You might be equally skilled. That is an excellent point. You mentioned people. Tell me a little about that.
The larger public defenders, the majority, from what I've read, it's not a fact, can't prove it. Most of their cases ended in pay lawsuits.
So our system does.
If I want to bring a personal story, the first time I went to court and I got a public attorney, last time I got a public attorney, by the way. That person worked, I think 45 minutes on my case. Yeah, it didn't go well.
Do you feel as though that wasn't as effective of a defense as you could have had?
That my attorney was also running for judge at the time against them. It was just bad time. I don't think personally she just said I'm not really going to work on this case. I just think I was just an insignificant number.
And so when I say you get what you said, you get what you pay for. I want to stress that because I don't want to give you a negative impression of public defenders in their function. They serve a function and they're skilled at their jobs. But when I say you get what you pay for, you're getting time. You're getting the time of somebody who you literally are paying by the hour. Now, to get back to the point that I was making, back to homicide. If you were arrested for homicide, 187, $2 million bail. It is not cheap to be defended. It's not cheap to be defended on a minor case. It's not cheap to be defended, especially on a major case like homicide. You've already shelled out $200,000 just for the right to not stay in jail while you're waiting for your trial. As Mr. Thornton talked about, the idea of not losing your job because you're sitting in jail, you can't go to work. That's part of the fairness, the rightness. Is it right that because somebody was accused of a crime that they have to lose their job because your job's not going to keep you? Your job's under no obligation to, oh, well, you're in jail. It's not right. We can't fire you. If you don't come to work, you're not going to get your paycheck. They have maternity leave. They don't have jail leave that I've heard of. Your house, the bank. I don't know how many banks are going to work with you and say, oh, well, you're in jail for the last couple of years. We're going to let the whole mortgage payment slide. Or you don't have to pay rent. I get it. You're in jail. Losing your home, losing your job, losing the ability to take care of your kids. Those are all functions of or effects of the bail system. So something to think about as far as whether or not the system is right. We're not going to get an answer today because that answer is being debated, has been being debated for years. Who does it affect more? Those who are affluent or those who are not affluent? If you have money and you're accused of a crime, the criminal justice system has a different affect on your life than if you don't have a lot of money and you're arrested. whether it be your representation, whether or not you sit in jail or not. Some jurisdictions now, many jurisdictions now, are exploring the option of getting rid of bail. Letting folks appear on their own recognizance, it's called. You'll see the initials in your text with ROR, released on your own recognizance. And it's essentially a ticket saying, you promise, like if you got pulled over on the side of the road. When you get pulled over on the side of the road, you get a ticket for speeding. That ticket, when you sign, is being released on your own recognizance, because you have the right, when you're pulled over and you're given a citation, you have the right to speak to a magistrate right then. It is absolutely your right. So you choose when you receive that citation, whether or not you want to speak to the magistrate that moment, that day, or you want to wait 45 days and talk to them and have your trial. By signing, you're saying, yeah, I don't need to talk to the magistrate right now. I'll talk to them in 45 days. Because if you don't sign that citation,
You're gonna see the magistrate anyway.
then how's the only way you're going to see a magistrate that day?
Because
There you go. It's your right. But you can waive your right and wait 45 days, 60 days, whatever your citations are. Same thing with own recognizance, release on your own recognizance. You can go to get arrested for burglary. And then in these jurisdictions that are getting rid of or reducing the bail, sometimes down to zero, they're saying, well, here's a court date. Do you promise to show up? If you do, then you can go.
I guess it would depend on the charge. I mean, like simple shoplifting, there's no point in it, trespass, jaywalk, contempt of cop, whatever. I mean, anything that causes damage to property or, I guess, damage to people, I guess. Yeah.
Well, as it started, the way I saw it build, again, no references for this, but as I've observed the process, it started out with it's always been with infractions. Then it increased with misdemeanors. Like most of what you described there was misdemeanor, trespass, shoplift, larceny, petty theft. The idea that if there's less than a year of exposure, we can release them on their own recognizance. As we got into the COVID era, wanting to reduce incarceration rates, felonies started to get thrown in there, lower level felonies,
Like
property
car theft
crimes.
and stuff like that.
Even though burglary is a property crime. What's that?
Like car theft and stuff.
Car theft? Yeah, car
Because
theft is a
before the
property
guy
crime.
got stabbed in 4
Grand theft is a felony version of larceny. In general, grand theft, the difference between grand theft and petty theft in general is just the amount that was stolen, the value of what was stolen, with some exceptions that the item could be a disseminating factor, a differentiating factor for. So in general, like in California, the difference currently is $950. You steal less, you steal $949, it's a misdemeanor. You steal $951, it's a felony. 950 and a penny is a felony. So other jurisdictions will talk about, it doesn't matter how much it's worth, a specific item that is stolen can be or will be a felony. Livestock, doesn't matter if it's a $950 horse or not, you steal a horse, it's a felony. You can steal a $5 horse, it's a felony. Guns, you steal a $100 gun, it's still a felony, doesn't matter how much it's worth. You've heard the term GTA, Grand Theft Auto? That's because that auto is what makes it a felony, not the value of the car previously. That law's been changed. But the fact is, it's Grand Theft Auto, because that was a $10 car, $100 car, it was a hoopty. But you stole a car, so it's a felony. Doesn't matter how much it's worth. Again, that law was changed. Proposition 47 changed that law. Now, the jurisdictions in California have to prove that that car is worth at least $950. But if we reduce all those crimes and say, we don't necessarily need to keep those folks in jail for the entire time while we're waiting for trial, then it makes it a bit more equitable for folks who have money versus folks who don't.
Yeah, but then you have those cases where they get back out there and they're waiting for trial and they're just sitting out there and everything they've done up to the point calculates up to something else while they're out there.
What do you mean?
So And I use my cousin as an example because it was stuff people should have seen. We sent him to South Carolina for school. He got into one of the best schools down there and ended up having a drug issue.
Mhm.
And so when he got back because he had ran into several problems down there with the police. And like, when I tell you, they beat the dog crap out of him. And it was a situation, whatever he got into down there, when he came back, he was definitely different. But nobody really wanted to deal with his difference. So they sat him with my uncle, and my uncle pretty much put him outside of the house. So he was out there, he was by himself. He got back to dealing with drugs. And then it just escalated from there until he stabbed a dude at 4 Oaks.
Well, that brings me to my next, it's like you're looking at my notes, it brings me to my next point. The idea that is there partially incapacitation. We'll do a quick review. Somebody tell me what incapacitation is as a theory of punishment.
Just lock them up so they're not in the area to do any other crime.
Can't commit more crime if you're already incarcerated outside of whatever crimes are occurring inside the environment, the prison environment.
So in that
So
way, I want to
somebody's
say that
in
it costs
jail.
more that he was out than being locked
In
up.
crimes.
Right.
So do we risk? So we've already said it's more fair, we use that term fair, more right for folks who can't afford to cut a check. If you're accused of a crime, that you're released without bail, because that's just as fair as somebody who they can't cut a check. Can't cut a check, can't cut a check. Everybody has the same access to freedom while they're waiting trial. However, folks that are arrested multiple times or have more are more prone to criminality. If you're not in jail, the opportunity to commit more crimes is available. The incapacitation effect is not there.
And it was crazy because once they actually had the thing on the news, it was like a list of stuff. And it was like, well, then why didn't they lock him up here? And why didn't they do something here? And then you see people up there and they're like, oh, they should hang that. And it's just like, okay, but where was his help at? I mean, it's too late
Sometimes
to ask for
incarceration-
that once he's killed somebody, but where was his intervention?
So sometimes locking somebody up is help for the offender by preventing them from committing other crimes, and help for any potential victims. It doesn't have to be a homicide victim. It could be back to burglary. None of us want our house broken into. The person that broke into the house could have been locked up if they couldn't afford the bail, and so there's your balance. Is it the rights of the offender to get out, or is it the rights of society to be safe from further victimization?
Well, they kept him out because COVID had hit,
Right.
but at the time that COVID had hit, he had stolen a couple cars like that weren't even from out here. Like we were seeing him all over. Cause I checked papers and stuff, and
Yeah. So
I was
that's
just like, what are you doing?
that's a good example of somebody where a crime perhaps could have been prevented. In this case, a homicide could have been prevented had the person been in jail, pre-trial incarceration. However, it is a balancing act. It is a balance between the right of an offender. Any of us could be accused of a crime, the rights of the accused. Because when we talk about the rights of the accused isn't always somebody on the other side of town accused of a crime that we don't know, a faceless person in the JOCO report. Any one of us could be accused of a crime if there's enough probable cause.
Right.
Doesn't mean that we committed that crime. However, the rights of the accused also have to be balanced with the rights of society, where society has a right to not have their house burglarized if we can prevent it. Any questions on what we talked about today? All right, you guys enjoy the rest of your day.